welcome to the final session of the People's Law School. I'm your moderator, Laurence Springberg, your moderator for the series. We have two sessions tonight that will be about 45 minutes each. We anticipate a lot of questions on these topics, and we'll try to spend a little bit more time on questions than we have in the previous sessions. As a reminder, if you have questions, please write them neatly on your index cards and hold them up for us to collect. We will take a 5-minute break after the presentation ends at 7 o'clock. Also, at the end of the program, we would like to take a group photo. After the last speakers are finished, we would appreciate it if all of you would come down to the level here so that we could take this photograph. And now I would like to introduce our first two speakers on the subject of family law, Dina Romaya and Tom Standish. Dina grew up in San Diego, California, where she graduated from San Diego State University with a bachelor's degree in both political science and sociology. Dina also participated in the Study Abroad program at Oxford University in England and Moscow State University in Russia. After college, Dina moved to Las Vegas to attend law school at the Boyd School of Law. While in law school, Dina externed for the office of United States Senator Harry Reid and the United States Immigration Court. Dina also served on the executive board of the Student Bar Association. She currently practices law at the Hanratty Law Group. Tom Standish devotes his practice exclusively to family law, family law litigation with emphasis on significant contested matters in custody and property division. Mr. Standish obtained his law degree from Osgoode Hall Law School in at York University in Toronto, Canada. Mr. Standish has served as a member of the State Bar of Nevada Fee Dispute Committee, the board of the Nevada Justice Association, serving as president of the Nevada Justice Association in 1995 to 1996, co-chairman of the Nevada Justice Association Domestic Law Committee, Citizens for Justice board member, and the Family Law section of the State Bar of Nevada. He has also served as an adjunct professor at the William S. Boyd School of Law on a regular basis during the past 6 years, teaching community property and family law. Please join me in welcoming Dina Romaya and Tom Standish.
Hello, thank you for coming.
Good evening. We have a number of topics of family law to talk to you about tonight. You're really going to love it. Family law is very exciting. I'm just kidding. But actually, family law is important because there's probably nobody in this room that doesn't know somebody or themselves been involved in a family law case or a family law related case in the last few years. It's a constant thing in people's lives that they are accessing the family court. We have a huge family court in Las Vegas that handles a lot of cases every year. And so we find that family law comes down to a human level constantly, where people can identify either for themselves or their relatives or their friends who have been in the courts or had a family law problem or a family law case. And so we're going to try to point out to you some of what is in our outline tonight on the topics of family law, teach you a little bit about the law, and give you a few comments on how that law sometimes is applied. And hopefully you won't have too many questions at the end. But as Larry said, you can write down questions and we'll try to answer those after it's over if you have queries about something or don't understand something we were talking about.
Okay, with that, we'll get started.
And we have this really great PowerPoint thing, which is really just our entire outline up on the screen. So the first thing I'm supposed to tell you is try not to read it all. That's not the intention. We will sort of summarize it for you. You can have a copy of it, as you know, and you can read it later. So we'll try to hit the high points and bring some of it alive for you to make it make more sense, perhaps.
All right, marriage, the #1 cause of divorce. You have to consent to marry, and then you have a ceremony to make it official. Here in Nevada, we don't recognize common law marriage. Common law marriage is where you're not legally married, but you hold yourselves out as husband and wife. You live together, you buy property together, you take your husband's last name, you bicker like husband and wife. You hold yourselves out as a married couple, but you're not really married. We don't recognize that. So that doesn't get you anywhere. Here in some states, they do. We only recognize a marriage between male and female. That's right now in 2012. What the future holds, I don't know. I know it's a hot topic. That might change, but for right now, we only recognize a union between a man and a wife. You need to be 18. You can be 16 with the consent of a parent, although I don't recommend it to get married under the age of 16, because then MTV will pick up a show like 16 Pregnant and Divorced, and you don't want that. So, with one parent's consent, you can marry between the age of 16 to 18. With younger than 16, you need a court order. What we do have, Tom will talk about, is a domestic partnership. We recently passed legislation where a same-sex couple, or even a male and female couple, there's no distinction, can register as domestic partners, and you essentially get all the same rights and obligations that you would as a married couple, but you're not married. It's not the title of a marriage, but it's essentially all of the same rights and privileges.
Yes, the Domestic Partnership Act was designed to, gee, I have to be politically correct here. The Nevada legislature did not address same-sex couples being able to marry. What they did is they created this structure where you can go and register with the state of Nevada as a domestic partnership, any two people. And when you do that, the important part of that is that all of the community property law, all of the alimony statutes that we have, all of those protections would apply to that couple. It would be as if you were married. Oh, the legislature doesn't want me to say that, but it would be as if you were married in terms of the law applying to the relationship. So if you acquired property to divide, it would be done under the community property statutes, like for married couples. If you had an alimony claim, same thing. So they basically provided for those people to have the same civil and legal rights as married couples, but they would not be married under the definition of marriage in the state of Nevada. So, and that's important because I can tell you just from the limited experience that I've had, there aren't that many cases of unmarried couples who come to family court and have lived together, acquired property, and now have a dispute as to how to divide it. The law is not clear on that subject, quite honestly, and sometimes it's very difficult to sort out what people's rights are. So as lawyers, obviously, we like to have people be able to take advantage of the laws in a clear and precise fashion, and that's much easier to do if you register as domestic partners under the Domestic Partnership Act. People have also done cohabitation agreements. You really need a lawyer to do that so you know what rights you might have or what rights you want to acquire by reason of a cohabitation agreement, but that is a private agreement you do between two people, whereas registering with the state under the Domestic Partnership Act gives you a formal structure for how you would exercise your rights if you had to divide property or you broke up.
Right. And the problem is people don't think to do that. You start living with someone and it's not an issue until 20 years later when you're trying to separate. You're like, crap, we should have gotten married. We should have had a cohabitation agreement 20 years ago. So, contract.
Well, contracts altering legal relations. Basically, when we talk about that, I talked about a cohabitation agreement. Generally, what people are talking about is premarital agreements when you talk about contracts altering legal relationships. We have certain definitions, what we'll go over in a minute, about community property law and separate property and those concepts when two people get married. But under Nevada law, you can opt out of the existing law, if you wish, by executing a premarital agreement. And to have that be enforceable, you have to comply with the terms of the act. Back in 1989 in the legislature, one of the influential legislators was getting married, and all of a sudden they rushed through an act about premarital agreements. It was just a coincidence, I'm sure. But we do have an act. It's a uniform act that goes across many, many states in the United States, Uniform Premarital Agreement Act. And it sets forth what you need to do in order to have an enforceable agreement and so forth. But you can opt out of and change the law on just about any subject in a premarital agreement. For example, in Nevada, you could eliminate either party's right to claim alimony. You could decide that there would be no community property in your marriage and that each of you would just keep as your own separate property what you earn from your job, and so forth and so on. You can opt out. I highly recommend, though, that you have somebody to do a premarital agreement for you if you're contemplating one that has experience doing them. Lawyers are not necessarily familiar with the ins and outs of that act. It's very specific, and you need to have a background in it. So you need proper legal help to do that.
And they're frequently challenged, and the problem is you don't know its enforceability until it's too late. You know, you've been married 10 years and you're trying to get a divorce, and that's when you get that ruling on whether the agreement's enforceable or not. I think Tom mentioned you can basically agree to almost everything. I think custody would be the exception. I sometimes see it pop up in premarital agreements. You know, they're like 22 years old and they don't have any children, and they agree to a certain custody arrangement in the event if they have children. That's generally not enforceable that I've seen. So don't bother with it, I guess.
Generally speaking, courts, we'll talk about this a little bit more in
custody.
Child custody. Courts will not be bound by parties' written agreements regarding custody. I mean, the court's going to exercise its own power to make sure that children are protected and that whatever is done is in the best interest of a child. So are we on to
whatever you like.
Definitions? Okay. Nevada is a community property state. First of all, before we talk about that, community property is a very interesting concept. All of the community property states in the United States, I believe there's 13 now, are all grouped together in the western United States. Nevada, Arizona, California, Colorado, they're all Arizona, they're all there, and so forth. Some states like Oregon are not technically community property states. Oregon kind of made it up as they went along, as far as I could tell. But all of the community property states that are strictly have those laws are all together. The reason for that actually is that community property is a Spanish concept that came from Spain over to Mexico and came up through Mexico to the western and southwestern United States. That's why those states have those laws, whereas the rest of the country has slightly different laws, equitable distribution, not community property in most of the eastern states, and so forth. So community property is really pretty simple, but it's easiest to understand if you are told what is not community property. So that is called separate property. Something that's not community that both parties are going to divide is called the separate property of one person or the separate property of another person. And there's only a few categories of separate property. It's what you own before you're married, remains separate property after you're married. It's what you inherit, meaning somebody dies, they leave you an inheritance. That's separate property. No matter when you get it, during the marriage or whenever, it's still separate property. And a gift. The gift area is a little tricky. The best way to understand it is the following. If you get a wedding gift when you get married, that clearly is a gift to the bride and the groom. But if you get a card from your mother at Christmas time that says, "Dear so-and-so, this is a gift for you and not for that no good husband or wife that you have," that's a gift just to you. So gifts just to an individual person, not to the couple, are separate property. There's some other classifications of separate property, such as certain portions and recoveries in a personal injury case if it's for your pain and suffering or your disability and so forth. Everything else in the way of property or money that's acquired by a couple during the marriage is going to be community property. It's as simple as that. Meaning anything you earn from employment, any bonuses you get, stock options, retirement contributions, anything related to that is going to be community property. Community property is divided 50-50, and in Nevada that is an equal division statute, very strong. They rarely depart from the 50-50 unless somebody has actually done something wrong, like stealing money or wasting it, spending it on their boyfriend or girlfriend. Remember that? Very few classifications. It's very much an equal division state. We are not an equitable division state. The judge in Nevada in a divorce case does not have the power to say, well, I think it's fair to give Mrs. Smith 75% of the property. I just like her better. And I'll give Mr. Smith, who I don't like, 25% of the property. They can't do that. They must divide it equally, assets and debts. So now you know everything there is to know about community property. Easy. You don't even need a lawyer for your divorce, right? Wrong. The problem is that although it starts out being very clean cut, like I've just described, we as human beings on planet Earth manage to mess it up. For example, you get your inheritance from your rich uncle, but then you put it into an account that has both names on it. Did you mean to gift half of it to the other person or not? I mean, who knows? We have a million fact patterns in our cases that mess it up. For example, you own your house before marriage. After the marriage, you don't transfer the title to your spouse. But during the marriage, you make mortgage payments, and that mortgage gets paid down with community funds. We have case law that says, oh, well, wait a minute. Now the community has a pro rata, like a piece of the action on that house that has an interest now. That happens a lot. And so commingling, meaning mixing up your separate property with community property, that can cause issues. Pro rata shares, like the mortgage payments made with community property on a separate property house, those are all ways that you all mess up this perfectly simple statutory scheme we have here. And that's why we get into, it can get very complicated very quickly, and which is why you do need a lawyer's advice if you're trying to sort that out when you get divorced.
And the problem is you're not thinking about that stuff when you're married. You're like, oh, he's my husband, I love him, sure, I'll take my lottery winnings and spend it on this.
Wait,
or
what do you mean? They're not studying the statutes every day they're married? What is wrong with them?
People are in love and they just spend on their spouses. That's where the problems lie, and that's why we have jobs. So the other issue is I want you guys to be clear on how you title it is irrelevant. You know, people say to me all the time, but I bought the house just in my name, or that's just my car, or it's my retirement. I've been paying into it for the last 30 years I've been working. It doesn't matter. It doesn't matter at all. Title is completely irrelevant. If it was earned during the marriage, it is community. If debt is a big issue. My wife spent $10,000 at Victoria's Secret and she's not using it on me. Well, it's still a community debt. It's a community obligation. It gets split 50-50.
That's right, and it depends on who does the titling. For example, if you get your bonus and you go down to the car dealer and you buy a car and you put it in your own name, that's what Dina's describing is. Just because you titled in your own name doesn't mean it's not community property. It's the source of the funds that really is most important. On the other hand, I've had several cases, I swear to you this is true, I've had several cases where I said, well, was that expensive car a gift to your wife? Oh, no, Tom, no, that wasn't a gift. No, that's community property. Then I call up the lawyer, and the lawyer says, we have 25 people that are at the birthday party. They had a bow around the whole car, and he gave it to her, honey, here's your birthday gift. So it depends on how the title is done and how it's given to somebody. Under that scenario, if the husband bought the car with community property and then deliberately put the title only in the wife's name, you would argue, what? A gift. So that could make it her separate property. I mean, that's not a slam dunk, by the way. You do need to talk to your lawyer about that issue. Some judges don't really find a gift that readily on that large of an item. So it's sometimes it's a different result.
Generally, our legislature, they want everything to be community property. So they start with that presumption. And if you want it to be anything different, the burden's on you to prove it's your separate property. Otherwise, it's all presumed community across the board.
The main thing is to dispel what I think TV and other people have perhaps confused is when you get married, everything you own is not automatically community property. That's for sure. In fact, if you think back, I said separate property, one component of it is what you own before marriage. So that furniture that you put into the new household with your new spouse, if you owned it before marriage, it's yours. If you had your car before marriage, if you had that bank account before marriage, it's yours. You don't need a premarital agreement. You don't need to worry about it if you kept it always in your own name. It's when you recover the couch that you had before marriage with community funds, or you put a new engine in that car you owned before marriage with community funds, that it all gets messed up. So, okay.
Right, or the home improvements. The house are, I think, the biggest issues. Back when they used to have equity, they were actually an asset in a divorce. You know, like he said, you buy, it's your separate property house, you owned it before the marriage, but then you move your new spouse into it, you pay the mortgage with it, you put in a new pool, you spend all these improvements. The community has a significant interest in the home, even though it was yours before marriage. Because all of your earnings from your job, from your employment, whether you had it before marriage or after, it's all community. And if that's what was being used to pay the mortgage, again, that's a community interest in the house.
So
where would you like it to be? Death? If your spouse is dying, don't divorce them.
That's so depressing, really.
Because you get it all while you're still married.
Let's see, management of community property. We skipped over that.
Did I? Oh.
Didn't we?
All right.
You know, this is an interesting statute. I mean, you might want to look at it. I'm not going to go over it, but we have a statute that says that during the marriage, basically, it's kind of like a general partnership where your general partner goes out and enters into a contract and you don't even know what the heck he or she is doing. That's what it's like in marriage too. You really have the authority to go out and do things, but then there's a whole list of things in this statute. It's under this title, Management of Community Property. These are actually the subsections of the statute that say, well, these are things you can't do. For example, you can't take out a mortgage yourself against the jointly titled house. You know, they're common sense things that you can't do. You can't empty out the house of all the community property furniture and take it down to the pawn shop and pawn it. You can't do that alone. But you could go to Sears or some store and you could buy the washer and dryer and enter into an installment contract all on your own. I mean, it's interesting to see how they do that. But I hope I haven't ruined anybody's day about that your spouse could be out doing all these things. If you feel the need to leave and make a telephone call, I mean, go ahead. Okay,
Right.
death?
Sure.
We have to talk about death? No.
Oh, well, just, you know, if they're
Didn't
dying,
they cover
stay
that
married.
under wills? If you don't have a will, there is a statutory scheme in the probate statutes for how your estate will go. So unless you want your estate of community property to go completely 100% to your surviving spouse, because that's what happens if you don't have a will saying otherwise, that's what happens. Your separate property will also go all to your surviving spouse unless you have children, in which case, again, this is if you don't have a will saying otherwise, then your separate property will be divided between your spouse and your child 50-50, or 50% to your spouse, and I mean 1/3 to your spouse and 2/3 to however many children you have. So that's the scheme we have. So unless you like that division, you should have a will. And then you can bequeath in your will your 1/2 of the community property to whomever you want, and all of your separate property to whomever you want. So you didn't need a wills and trusts lecture. I just covered everything there, right? Okay, good. All right, now we have to talk about divorce.
Oh,
Dear.
that's our topic.
Oh.
All right. Division. This happens generally at the time of divorce.
Yes, that's true. We had some talk already about entering into written agreements like a premarital agreement before you get married. That obviously can, if it's a good agreement and the judge will enforce it, if it meets the requirements of the statute, in other words, then you can already have that issue done. I can tell you, by the way, premarital agreements, I don't know if people realize this, but the major reason to have a premarital agreement isn't necessarily just to protect property or to alter your rights. It's to avoid having to hire lawyers and fight over those issues when you get divorced. Because as you can see, they can get very convoluted. And so what that means is that if people can't agree on it, then you have to pay lawyers and it can be expensive. So otherwise, Dina, are you going to talk about dividing community property, or we already covered that?
You covered that.
We covered it. Okay.
Alimony.
Alimony.
We'll get to alimony.
Before we do that, let me also
Oh.
add that in terms of division of property or an award of alimony in a trial or in any case in Nevada in divorce, Nevada is a no-fault state. And what that means is that Nevada does not have, the judges in Nevada do not have the power to, for example, unequally divide property or award a certain amount of alimony based on what they think is a moral fault of somebody. For example, one spouse had an affair with somebody and that broke up the marriage. Many people would say that's a moral fault. That's not a basis, though, under our law to do anything in the judge's jurisdiction over the case, to do anything other than still divide things equally or award a fair amount of alimony based on the factors we'll talk to you about. But you don't get to punish somebody in Nevada courts when they did something wrong that was morally wrong. For example, it even comes down to, there was a very significant case on alimony that went to the Supreme Court, and the Supreme Court said, look, Mrs., I forget the name, I think it was Rodriguez, should not receive a greater amount of alimony because she was beaten very badly by her husband. What she should receive, though, is full compensation for any time she lost from work or any medical bills she had as a result of that. I mean, she should be made whole for any economic impact of him doing this morally bad act, but the actual amount of support that she should receive, you know, it should be based on the factors of, you know, how much money there is in expenses, not on his moral fault. And that shows you the limits of the Nevada law. If any time you were going to punish somebody, that would have been the time, and the Supreme Court said, no, we're going to stick to our no-fault scheme. So what you see on TV, you know, going around and following people to get the goods on them if they're having an affair, might be grounds, you know, for somebody to feel they need a divorce, but it will not help them to get a better deal from the court, so to speak. So.
I know you wanted to mention, generally all proceedings are public in family court. All of everything you file is public. Anybody can get a copy of it. I know one thing that really bothers my clients, I was always taught that income is kind of a taboo subject. You're not supposed to talk about how much you make or ask other people how much you make. Every divorce case, every custody case, you are required to file something called a financial disclosure form, which lists all of your income, attaches your last 3 pay stubs. I mean, it's all out there. Lists all of your assets and debts, everything you own, basically, goes on this document that is part of the public record. So a lot of people opt to have their cases sealed if you don't want, you know, all of Clark County and anyone with access to the internet basically having that at their hands. So you can ask for closed proceedings, what they call sealed cases, or nobody will be allowed in the courtroom. You can't even look it up that the case exists. So you do have that option, you do have that right. It's upon request, but otherwise the media has a field day with demanding all the proceedings be public and want to get in there.
Meaning that your lawyer has to prepare an order sealing the file and submit it to the judge, and the judge will sign it. And that means your file is sealed and the public cannot go to the internet and they can't go to the clerk's counter and ask to look at your file. Family court files on the internet that are not sealed are different than civil cases. In civil cases, you can go into the case, you can see each document that was filed, and you can read the document. Family court cases, there's not that type of access. They have limited it to the extent that you can see what's been filed, but you can't necessarily just go in and get every single document. But if you seal the case, then the case does not appear on the internet, and you know, you're protected that way if you wish to do that. But you have to submit the special order and get the judge to sign it. As far as any hearing in family court, whether your file is sealed or not, you can ask the court to close the hearing, and they will make everybody get up and leave. And the only people in the courtroom will be the bailiff and the court clerk and the judge and, you know, the court personnel only, and the lawyers and the parties. There's been a statute passed a couple of legislatures ago. One of the legislators was really mad that he was excluded from his son's divorce case. So immediate family members can sit in, and then the judge, under certain circumstances, could even exclude them, but it's up to the judge. Otherwise, your brother
siblings
or
and
your mother, your father, your
degree.
sister could be there, and therefore your children, but anybody else still is going to be excluded.
Okay, alimony.
Alimony, a subject that strikes fear into many people's hearts. Alimony or spousal support, the terms are interchangeable, is a payment from one party to the other for the support of the party that needs the money. It's discretionary in Nevada with the judge, and it can be awarded on a temporary basis while the case is getting to trial, or it can also be awarded at trial for however many months or years the judge determines. We do not have a formula, an algebraic or mathematical formula in Nevada saying if somebody makes this much and somebody else makes this much, then they get this much. We do not have that kind of formula. The judge takes into account, off of the forms that Dina mentioned earlier, the financial disclosure statements, looks at both parties' expenses, or what the judge thinks are reasonable expenses, what both parties have as income, and makes a decision whether the payor can afford to pay alimony, and always taking into account if child support is being paid. And then they make a determination what they think is fair. I think the family court judges, I personally think the family court judges do a pretty good job of being pretty consistent in their cases. I know some members of the bar think otherwise, but I think that it is somewhat predictable. But there's a split of opinion, I can tell you, among lawyers that do family law as to whether a formula is a good thing or a bad thing. I was very surprised to learn just a couple of years ago when I was asked to participate in a seminar. It's actually the Supreme Court had a seminar, and my co-presenter searched all the states, and there aren't any formulas out there in states. California has one for temporary orders, but virtually no state has a formula. I thought they all had formulas, and we were the only one that didn't. So it is common to have judges just look at each case, because every case really is different, and make those types of decisions.
And I was teasing Tom because in the handout, he bolded the word husband where he says wife or husband. It is not spouse specific. I don't think I have ever had a male client request spousal support, no matter
I
what
have.
the.
None of my clients are shy about
I
that.
have to advise them that they have that option to seek that, but I feel like, they thought they were being castrated just by asking for support from their wives.
Nevada
And-
has done away a long time ago
Yeah.
with any type of gender bias, whether it be property division, alimony, or child custody or anything else.
Right.
It's just gone. We'll talk about that in custody a little bit more, but if somebody says to you, the man or the woman always gets this or that, they don't know what they're talking about.
Right.
I really do think, I personally really do think our judges in family court do not have gender bias. I think that what many attorneys mistake for Judge X being a woman's judge or a man's judge is whether they're sympathetic or not. Some judges are much less sympathetic than others, and perhaps that confuses lawyers on that issue. So where are we?
Just if you want to mention rehabilitative alimony.
Good idea. I'm glad you're here.
Well, just briefly, it's those cases you see a lot where it's, husband and wife, they both maybe made like $40,000 a year when they got married, and then, honey, why don't you go to law school first, or why don't you go to med school, or no, why don't you go, and then I'll go. I'll put you through, law school or med school, whatever you want to go, and then I'll go. And then they don't stay married that long. We've got, maybe husband went to med school for 9 years or however long it took. He went from making, 40 before the marriage to 250 by the time they're divorced, and wife didn't have that opportunity to obtain that same education. There is relief in courts for that situation beyond just he makes more money than you, so you get this much alimony. Does that cover it?
Oh, so we're good.
We're okay?
Okay, so we have time, so I'll expand on that a little bit.
All right.
Generally, alimony in Nevada does have two different forms. What we've been talking about mostly is just, it doesn't really have a name, it's just alimony or equitable alimony, what the court thinks is appropriate. Rehabilitative alimony comes in the following circumstance. You're really talking about, in any regular alimony situation, that if the person who wants to get alimony is capable of working, they have to go out and work full time. I mean, I think that's a rule that all judges follow. You expect the paying spouse to be working full time so that you can receive an alimony payment for them. Well, then you have to work full time, unless you're disabled or whatever. Staying home to take care of the children, for example, that's not going to happen in our courts here if you're talking about an alimony award. It's not. You're going to be required to work full time. The alternative is to say to the court, as an alimony candidate, to come before the court and say, look, Your Honor, I can't work full time, but this is what I'm going to do full time. I'm going to go back to school, or I'm going to take this special training, or I'm going to enter this course. I'm going to complete it. I'm going to work at that full time. It'll take me this many years or this many months to do it. This is the cost of doing it. But when I get done with that, I can enter the labor force and I can get a job at a higher level. So myself will benefit from it, I myself, and really my spouse will benefit because there'll be less alimony payable to me, perhaps, if I can earn more in the future. I think judges look on that as a positive thing for both parties, and I think that they would encourage that. But you have to come to court with a plan, not just, oh yeah, maybe I'll go to UNLV and maybe I'll become a forest ranger, or I'm not sure, maybe a dentist. You have to have a plan so that the court knows how long it will take, how much it's going to cost, how many years it'll take you to get to the point of being able to enter the labor force at that higher salary. And that's why they call it rehabilitative. And that's what Dina was talking about, is to rehabilitate the person, to bring them up in their skill level so they can bring them up in their income level. The difference is the spouse that's paying has to pay a full measure of support because the other spouse is not working at all during that period of time. So there's a trade-off. Hopefully it all works out in the end. And lastly, people ask a lot about the term, the length of time the judges will award alimony. There is nothing in the statute that talks about that. It just says whatever is fair and equitable. We find, I think it's fair to say, generally speaking, although judges are not bound by any rule, that something like approximating maybe half the years of the marriage, especially in longer term marriage, and probably a third of the years of the marriage at a minimum, depending on the length of the marriage, is a rough range of what I see in terms of the number of years or months to be awarded. For example, if it was a 10-year marriage, then maybe 5 years of alimony, or maybe down to 3.5. I mean, that would be sort of a range that we see a lot happening. If you're married for a year or two, some judges won't award any term. Some judges would not give you a third of the months or half the months of that term of marriage. It's really up to the judge, and it would depend a lot on the circumstances. But alimony is based on two things generally. You have to have a need. You have to show the judge that you need money to live a reasonable lifestyle, and then you have to show there's an ability to pay, meaning in the other party, that they can actually afford to pay you. And unfortunately, in family court, every single day, judges make decisions with people that can't afford to pay what they should, and the other party can't afford to live on what they get. And so it's rough out there. That's a hard job, but I think the judges do the very best that they can in those cases.
Right, and I think what people have a problem realizing is that you're never going to be living as comfortably in two households separated as you did in one. And I feel like they keep trying to get back to that point, but it's just there isn't enough money to go around, because now we have 2 mortgages or 2 rents or, 2 cable bills. It's just not the same. It may be his $60,000 a year income was great when you were married, but split that 2 ways, it's just not going to go very far.
We all spend too much.
Yes.
We don't save enough.
Actions for separate maintenance. Just want you to know you can get a legal separation in this state, essentially the same process as a divorce. Really the only reason I see people do it is for health insurance. They want to separate all their money, kids, everything, but they still want to be legally married so that they can stay on that spouse's health insurance, especially if one party's ill and can't afford COBRA or something like that. Or religious reasons, I see that a lot. They don't want a divorce.
That's pretty rare. The separate maintenance statute is really restrictive.
Right.
It actually says the judge can't divide property. It's really just a situation where the couple separates, one party needs support, and it talks about support of the children as well, and they just aren't going to get divorced, let's say, for an indefinite period of time, but they need a court order, or party wants a court order. It's kind of an old moldy statute, to be honest. It's rarely used. But it does allow to have a permanent, indefinite order for support paid from one party to the other. So,
Annulments.
are you going to talk about what happens in Vegas stays in Vegas?
Oh, no, it doesn't stay in Vegas.
Annulment? Why not?
I guess void marriages. These are marriages that are just not recognized at all. It's as if you were never married to that person. What we have listed up there is, no, we don't have anything listed up there, I'm sorry. Essentially, your cousin, you marry your sister, it's not a marriage, it's not recognized. You are already married, and your first marriage is not, you didn't get a divorce. You didn't get that file stamp decree. Even though you remarried, that's not a recognized marriage at all. It's as if it never happened. So be very careful if you're in divorce proceedings. Make sure you are officially divorced. Otherwise, your next marriage is just not recognized at all.
I can't be married twice?
No. Do you even want to be married once?
No, once was enough for me. I'm good.
I read somewhere bigamy is having one spouse too many, which is the same as monogamy. Voidable marriages are, we do recognize them basically if you want us to. You can come forward and seek an annulment of the marriage, but if you don't, it's a valid marriage. That's the hangover marriage. That's the, we got drunk in Vegas and got married, right. and whoops.
Right, that's capacity. For example, if somebody has a mental problem, meaning they're insane, depending on the degree of insanity, that can actually be a void marriage because they never had the capacity to enter into it. But drunkenness is the funny and common example is you were so drunk you didn't even know what you were doing. That's a voidable marriage. You're going to be married unless you come and ask for an annulment. And understand the difference between annulment and divorce is that if you get married and the next day you get divorced, you've been married and divorced. An annulment means that you got married, you come and the court grants you an annulment, you were never married. It's like it goes back to the marriage and it wipes it out. That's the difference. So I guess that's good. I mean, it means that property and those sort of things that might have been acquired during the time you were married before the annulment would all just fall back to your single people and you were never married. So, which is why Britney Spears wanted an annulment, because she didn't want to have a claim. Maybe she did a concert while she was married, the day after she was married, and the man was going to claim a piece of that. Okay, so, but that's the idea of annulment, is that actually, and you can actually say truthfully under oath, if you were making out a form to some government agency, I have only been married once, when really you had a second marriage that was annulled, or I've never been married even though you got married and it was annulled, that sort of thing. So,
and we don't have any residency requirements for annulment. To obtain a divorce in Nevada, you either need to be a resident or the opposing party needs to be a resident. For annulment, not at all. You know, it could have been the drunk guy from Hollywood and the drunk farm girl from Montana or whatever, met here, got married and left. We still have jurisdiction to grant an annulment without anybody living here.
Which brings up another subject we didn't cover, residency. Just to dispel any notions you might have that are inaccurate. Nevada has the shortest residency period, meaning if you live here for 6 weeks, you can file for divorce. There's a lot of problems with that, but let me tell you that the courts do not look kindly on people who don't really move here and don't really reside here, coming for 6 weeks and then trying to claim they're a resident and get a divorce. They will ask you those questions, and you do have to swear under oath that you live here, meaning you have actually a home and you are going to get a driver's license and those types of things. That thing of the quickie divorce, you go to Reno, I guess in the movies, and 6 weeks later, boom, and then you just leave. You would not get a divorce if you told the court that's exactly what you're doing. You have to actually move here, reside here, have an intent to stay here, be here 6 weeks, and then you're eligible to file. And that doesn't mean that you can bring the whole divorce here either. I mean, we have jurisdictional rules, meaning rules whether courts can actually haul that other person in from another state and make them do the divorce here. You can't just do it because you're in Nevada, but you can get a decree. You might not divide any property, you might not deal with custody of your children, but if you're actually a resident in Nevada, even though your spouse has never been here, you could at least terminate the marriage with a decree of divorce. So.
Right. Children have to be here 6 months, even though the parties only have to be here 6 weeks. Right. So that doesn't make sense to a lot of people, but.
And you're going to explain that entire Uniform Act to them?
Absolutely. I'll put them to sleep. Okay, custody. So sole consideration is the best interest of the children. Not best interest of mom, not best interest of dad, not grandma, nobody else. It's all about the kids, which is ironic because you're never supposed to involve the children in the proceedings. You're not even supposed to talk to them about it. There's 2 kinds of custody. There's legal custody and there's physical custody. They're 2 very different things. Legal custody, you're either going to have joint or you're going to have sole. Legal custody, it's like custody in theory. It's decision making, it's information sharing. It's, we're supposed to talk about whether or not our child should have this major surgery. It's the big stuff. Generally, whoever has physical custody will be making all the day-to-day decisions. You don't have to confer with dad whether or not the child should have a haircut. It's the big stuff that you're supposed to confer about.
What if you want to get a mohawk or something for little Johnny? I mean, you don't have to consult on that?
I would say no. I don't think you'd be violating joint legal custody provisions. It's supposed to be big decisions about the health, education, and religion. Those are considered the big issues. We also have a list in here.
So any fit parent is going to get joint legal custody with the other parent, meaning they have the right to be consulted. Joint legal custody means you have to consult on major decisions for the child. And physical custody, the easiest way to think about that is it's where the child lives, which household on which days. So there's a distinction there.
Right, and I would probably say 95% of the time or more, you're going to share joint legal custody. Literally, you have to be in prison or just completely unfit for one party to have sole custody and them not even having just legal custody. And we say it's in theory because if you've got Disneyland dad who sees the kids twice a year, mom's going to be making all the decisions. And I don't think anybody's going to fault her for doing that. She's supposed to consult with dad, but if he's not around, he's not around. So physical custody. This is where the child lives, and this is where me and Tom make our money. Defining the difference between sole, primary, and joint. I would say there is a difference between sole and primary. Sole would mean no visitation to the other party. Primary, we define it as more than 60% of the time. Joint, we define it as 40 to 60% of the time. We don't really know what that means. We have Supreme Court case that says it's supposed to be 40 to 60% of the time, but how to calculate that is where we're kind of left in the dark. And where we calculate it depends on who our client is. You're not supposed to count hours. We're specifically told not to get that petty. We're supposed to look at days, but then we have issues arise as to who gets credit for the day. If you split the day in the middle, and we don't know. There is no answer to that. It depends on who's arguing louder in court. So the big difference gets to child support and if you eventually want to relocate with the children. I think that's the two battles why there's such a big difference between joint and primary. Generally, if you've got about 5 days a week or more with the kids, you've got primary physical. Joint is somewhere around 3 to 4 days a week, as close to 50% as you can get. And that's the best definition we can provide to you.
Yeah, the terms that we use in family court a lot are, when we talk about joint physical custody, that used to mean that it was a 50-50 split or very, very close to it. What Dina was talking about as to the 60-40 being, if you had 40%, you could still be a joint physical custodian by way of the labeling we're talking about, came from the Rivero decision that just came down a couple of years ago from the Supreme Court, a few years ago now. And the Supreme Court really made a policy decision in that particular case. They said, in effect, they said, look, to everybody out there, if you want to be a joint physical custodian, you can get that label by getting 40% of the time with your kids from the court in the physical custody decision. You don't have to get 50%. And I can tell you, literally, it can be the difference between having, 5 to 6 days a week with your children as opposed to, every 2 weeks, as opposed to having, 7. It's sometimes a very small difference, and the Supreme Court was trying to say, you don't have to litigate, you don't have to fight in court to get to 50%. We believe, as a policy, our Supreme Court said that you're a joint physical custodian of your child if you have 40% of the time. I think it was, the philosophy is good, is to have people litigate over their children less. But that's where the Supreme Court was going. And so we have different child support rules, a different formula that the Supreme Court set when you're a joint physical custodian than if you are primary physical and non-primary. So it can have an effect in the child support area too. One of the things I wanted to point out in the family courts in Clark County is that the family courts are very protective of children. The rule that Dina talked about, you are not allowed to talk to your children or your child about the divorce, that's a strict rule. Literally, judges every day say this to the mother and father in the courtroom. They say, you can tell your children, with respect to this divorce, that we both love you, that you're going to be okay, you're going to be fine, and that mom and dad are going to work it out with the judge. That's it. And they say it every day, and they mean it. And they will punish people who involve their kids. There's a children coping with divorce course. It's about 4 hours or so. Every parent in Clark County who has children who's getting divorced must take that course, or they can't have visitation rights in the decree or custody. And the whole course is designed to tell people, don't put your children in the middle of the divorce. Don't talk to them about it. Try not to fight as much. It just puts stress and pressure on children in ways that parents that are divorcing sometimes just don't understand. Children absorb the stress and tension of a divorce by osmosis. You can say nothing to your children, they're still going to feel it and they're going to see it, even if you don't talk to them about it, but talking to them about it is worse. And so it's a very difficult part of divorce. There's no question. It's the most important part, certainly. But understand those rules exist, and if anybody tells you differently, they are wrong. Children do not come to court to testify ever, in my experience, and I've been practicing over 30 years here. Judges rarely ever talk to a child of any age in a case. They appoint other people, either people from the Family Mediation Center that are trained to do that, or qualified psychologists that are trained in child psychology to talk to a child to find out perhaps what that child is thinking or feeling, or if they're older, what their preferences are. So they shield the children from the system as much as they can and from the process of divorce, because it's very tough on kids. And that's why the Supreme Court ultimately was aiming at cutting back on litigation. They're trying to protect children. It's the same thing in the Rivero decision, saying if you get to 40% and you really just wanted physical custody as a label, you're there. You don't have to fight anymore.
Right, but I think it's led to more litigation that it backfired. But he just put in the outline, to make joint physical custody work, you know, you need to live close together. You can't have joint custody living in 2 states unless the child's a baby, and then it's not in the child's best interest at that point. Have a combat-free relationship. I don't think you have to go that far. You're divorcing, so it's not combat-free, but you do have to work together. You know, I tell my clients, like, you don't have to, like, you don't have to send them Christmas cards, but you got to deal with them for the kids. You have to. It's in our statutes. It's required. Living close together and giving consideration to the proximity of the school. If you're going to share joint custody, you're both going to be sharing in the picking up and dropping off at school. So it doesn't work when one party's living deep in Summerlin and the other party's living deep in, you know, Henderson or Boulder City. You have to live close enough together where it's possible that you can still work around the child's school. From
the attorney's perspective, what happens is your client comes in and says, I really want to have 50% of the time with my little Johnny. Okay, that's great. And I just moved to Summerlin. And little Johnny lives in Green Valley? Yeah, but I want 50% of the time. See, you have to get up at about 4 o'clock in the morning to get little Johnny to school in Green Valley. And proximity is very important. I can't tell you, it just works so much better when you can have a cooperative relationship, but it also helps to be physically close to each other in terms of your residences. You don't have to live next door to each other when you're divorced, but it is a big factor in terms of the quality of life for the children or the child in terms of going from one house to the other.
Tom, Dina, I'm sorry, but we're about running out of time. We're going to have to go to the questions now.
Larry, I have many more brilliant things to say. I mean, I can't believe you're cutting us off here like that. Okay.
All right.
I just want you all to know that Larry selected these questions, and I'm not entirely sure if they're really your questions. So,
okay. The first question is asks, is the second wife's income included in the child support calculations for the husband's children from his first marriage?
That's an excellent question, Larry, and Dina's going to answer.
Generally, no. No, new wife does not have an obligation to support husband's children from previous marriage.
What the judges want to see is they want to know, when you put down, here are all my expenses, they want to know whether you're getting a contribution to those expenses from your new wife or husband. It makes a difference in terms of what they might award as child support, because it actually changes your income. I mean, if,
right.
You know.
Generally, no, but if I'm a stay-at-home mom because my husband makes $500,000 a year and I have a child support obligation, then yeah, it would be considered. But generally,
so the general rule is no, your spouse's income is not considered by the court. They don't take a piece of it, but they can consider it in the overall household and the expenses.
Okay. This wife would like to know, what are her legal rights if her husband has a successful business regarding, 1, her share of the net income of the business, and number 2, can he disinherit me? And I'm not quite sure that that's the right term, and you can answer it in terms of a family law. And finally, how can I release myself from an IRS audit since my husband is the owner of the company?
Okay, the answer to that question is, do you have a half an hour? I can explain it to you after we're done. That's hard to answer in a few sentences. The answer to the first question is, does she have a share of her husband's business? If he started it during the marriage, then it's a community property business. If he started it entirely with separate property money, then there could be a shared community and separate component. If he owned it before marriage, there's a complex set of cases, Pereira and Van Camp, old California cases, that deal with what approach the court would take to see what portion, if any, would be community property of the business. That's the shortest answer we can give. Okay. The second question, talk to us, whoever it is, afterwards, and we'll answer the second question, if we can.
For purposes of custody and child support, at what age is the child considered an adult?
I don't think the question is considered an adult. It would be consider their opinions in the child custody determination. We don't have an age in Nevada where we say that the child gets to choose where they live. And in some states they do. It's 14, it's 12, it's whatever it is in those states. Here it's our statutes say of suitable age and maturity. And that means something completely different to every judge in the courthouse. Some might say 12, some might say 13, some might say 16. And it's also a case-by-case basis. The 12-year-old who's a straight-A honor student might be more mature and able to give that intelligent preference. A 15-year-old who keeps running away and keeps screwing up in school, a judge might say they're not at a maturity level to give a preference. So
that was to custody, was the
that
question?
the question?
And more specifically, perhaps, is there an age at which the non-custodial parent no longer has to pay child support?
Oh,
Yeah,
I'm sorry.
Under our statute, that is defined as when two events have occurred. Either, one is they must have turned 18 years of age, and two is they must have graduated from high school. Or if they're still in high school, when they get to age 19, then continuously, then at age 19 it ends. But you have to have those two things. So if your birthday's in March, but graduation from high school is in June, then it would terminate in June. If graduation from high school was in June, but your birthday was in August, it would terminate in August. And if you were, I don't know, you were held back a year or something and you were still going to school, then it's going to end at age 19. If they drop out of high school, therefore, before age 18, it would end at age 18. I think that's everything. Don't ask me to say that again.
But that doesn't affect your ability to collect arrearages. I want to make that clear.
Right.
I mean, if someone didn't pay, you know, from age 2 to age 18, I mean, those kids could be 25, 30, and you're still collecting on the arrearages.
Correct.
There's no statute of limitations.
Right.
Child support doesn't go away. You can't bankrupt it. It follows you.
And we should add, the court has jurisdiction to extend child support indefinitely beyond that emancipation age of 18 in high school if the child is a special needs child. So if a child is severely disabled, for example, and needs support beyond that, the court can keep it in place forever, effectively.
And that's pretty much the only exception. So
Right.
just because they're in college or still living with you or still eating your food, the child support obligation ended.
I think we're ready for our group picture, everybody. All right, I'd like to thank Dina Romaya and Tom Standish for an excellent presentation on family law at this time. Let me just make sure. Dina, for your wall. Tom, another one. Thank you both.
Thank you.
Hello, I'm Larry Springberg, your host for the People's Law School. I'm also a lawyer specializing in accident and medical malpractice cases. The presentation you're watching is one of a multi-session series on the legal topics which affect the daily lives of Nevadans like you. As a member of our home viewing audience, you too can earn a diploma from the People's Law School and receive the course handbook free of charge. To receive a diploma and handbook, simply send us your name, address, and telephone number stating which sessions you have watched, and the information will be mailed to you. Mail your request to the People's Law School, 406 North Nevada Street, Carson City, Nevada, 89703, or call 775-885-7174. The supply of printed course material is limited, so don't delay. We welcome your feedback. The People's Law School is for you, the citizens of Nevada. So let us hear from you. Our final section today is on guardianship, probate, and estate planning. We have three very good speakers tonight: Marjorie Hauf, Bradley Richardson, and Kristin Tyler. Marjorie Hauf obtained her Bachelor of Arts at the University of Nevada, Las Vegas, and a law degree from the William S. Boyd School of Law in Las Vegas. She also received the Kelly Award for Law Practice Management in law school. Prior to her admission to the Nevada Bar, she worked in hotel casino management, and more recently, before becoming a lawyer, she worked as an insurance claims representative, investigating claims and negotiating settlements. Since becoming an attorney, Marjorie has been involved in the successful resolution of personal injury, wrongful death, and medical malpractice cases, as well as jury verdicts for over 7 years. Bradley Richardson is one of the few attorneys in Las Vegas with extensive litigation experience and expertise in probate, trust, and guardianship, and in particular, elder competency and undue influence situations, financial exploitation of the elderly, disinheritance, transfer of title, validity of wills, prosecuting or defending claims of breach of duties by executors, guardians, or trustees. Mr. Richardson began his legal career as a police legal advisor and assistant city attorney in Overland Park, Kansas, and later moved to Las Vegas, where he served as chief of the fraud division for the Clark County District Attorney's Office. Mr. Richardson is now part of a strong litigation department and has more than 26 years of experience representing major corporations in all courts of Nevada. In addition, he has a demonstrated track record in prosecuting those who have exploited the elderly. Kristin Tyler holds both a law degree and a master's in business administration from the University of Nebraska. She works in the estate planning, probate, and guardianship department of Gordon & Silver, where she is an associate. Her practice is focused primarily on estate planning and probate matters. Prior to joining Gordon & Silver, Ms. Tyler worked in a boutique law firm focusing on estate planning for high net worth individuals. She has spoken at various local seminars regarding estate planning. Please welcome these people for this fine presentation.
Thank you, Larry. I'm Brad Richardson, and as Larry mentioned, I am a former prosecutor in Clark County District Attorney's Office, and I've been faced with many challenges in the guardianship area, which is the area that I'm going to start with. I will switch from guardianship to probate, and then we will continue the presentation with regard to estate planning. But to start with guardianships, many times the guardianship issue comes up when there's been an exploitation. And the exploitation will generally be of an older person who's being exploited by a child or by a friend or neighbor. And because Las Vegas is such a unique city, and a lot of people live here, their family members and then their network is in another state, thousands of miles away. The only way these things get reported is someone will make a call to Senior Protective Services, and then the matter will be referred to the Clark County Public Guardian, Kathleen Buchanan. So you need to know the framework for guardianship in Clark County. We have a wonderful, long-serving public guardian, Kathleen Buchanan, who has an office that's staffed with caseworkers. We have a guardianship court. John Norheim is the guardianship commissioner. And we also have a Senior Protective Services who will investigate claims of exploitation of the elderly and follow up and make house calls, and will visit people who may be in jeopardy of being exploited and refer those matters to the Clark County Public Guardian. When is a guardianship needed? In addition to the scenario I have just outlined for you, a guardianship may be necessary when someone has become incapacitated and they may have a business that needs tending to, and a relative or a officer of that corporation may seek to have someone appointed as guardian so that the business can continue operating because the owner is incapacitated. In that situation, a petition would be filed and a hearing would be held and a guardian would be appointed if you can show that the ward, the proposed ward, is in need of a guardianship. There's a misconception that a guardianship can be attained over someone against their better interest, against their will. That's not the case. A guardianship hearing before Commissioner Norheim will require the ward to be present. It will require a medical report indicating the need for a guardian. If there's any question about whether a guardianship is necessary for this person, a guardian ad litem may be appointed to visit with the proposed ward and report back to the court whether it's necessary and who should be appointed guardian. How do we determine who that person should be? Guardianship appointments are interesting in Nevada because you have to have a Nevada resident as a guardian. Now, if you have a family member that may have been named in a document appointing or nominating a guardian that the proposed ward had drafted, executed, signed during their lifetime, and that person lives out of state, they're still going to have a Nevada co-guardian. So who would that person be? Well, there's private fiduciaries that can serve as guardians. The public guardian could possibly serve as a guardian, but I think their office has a rule where they won't serve as a co-guardian because it's too cumbersome and too difficult to have two people acting as guardians. So if you have a person who lives out of state and they're trying to get an appointment as guardian over a family member, they're going to have to consider getting a co-guardian in Las Vegas, Nevada, or of course in Reno or in any of the outlying areas. They're going to have to find someone willing to serve. It could be a private fiduciary in that area. It could be a friend or neighbor with some, if they're trustworthy and they're willing to do it. It's a thankless job. Now, there's also term conservatorship. It can be a bit confusing. Conservatorship is the term that's used in California. So a guardian in Nevada would be the same as a conservator in California. The guardianship statutes are found in Chapter 159 of the Nevada Revised Statutes, and we are statute-driven. So if you have any questions, you can look at this statute to determine what your obligations are. It's a very good outline of what the responsibilities and rights of the guardian are. Oftentimes I'm asked, mom or dad have indicated they might want a guardianship and they might want me appointed, but then they hesitate. But I know they really need it. What should I do? Well, oftentimes if you explain to mom and dad, and this is assuming mom and dad has some capacity to understand what's going on, they may, after some discussion and having the benefits of guardianship, explain the fact that the court will supervise and oversee the handling of their affairs, will become more comfortable with the thought that a family member might serve as their guardian because they will have to account to the court. Now, there's sometimes an attempt made by a family member to obtain a guardianship over mom or dad, and mom or dad are resistant. What happens in those situations? Well, mom or dad will show up at the guardianship hearing, and the guardianship commissioner will ask them if they want a guardian, or they will ask them, do you understand what we're doing here today? And if there's any hesitancy or question, the guardianship commissioner can order an evaluation to be done to see if mom or dad really need a guardian, if it's necessary, and sometimes even over mom or dad's objection, because we all are very stubborn about having someone control our affairs. He will talk with mom or dad and he will explain to them, listen, your doctor says you really need it, it's necessary, I'm sorry, but it's required in this situation. That's in the more severe cases. So you've got mom or dad who basically understand that they're in court, but they don't really understand the guardianship process, and there's no way they can handle their affairs. They can't protect themselves from exploitation. They can't manage their checkbook. They can't manage their finances. And so that situation is very obvious to everyone, but perhaps mom or dad. How are the guardians compensated? Guardians are compensated based on their time. So I advise those persons who have been appointed guardians to first take the class offered by, here in Las Vegas, the Clark County Public Guardian's Office, to understand their responsibilities, but to keep a log of their time, and keep a ledger of their expenses, and keep all their receipts. For if those receipts are valid, you can get reimbursed by the court. But without the receipts, you're going to have a very difficult time doing it. Well, what is a typical hourly rate for a guardian? Well, it could range anywhere from $15 to going to for mowing the lawn, to maintain the lawn, up to $75 for assisting the CPA in preparing the tax returns for mom or dad. So you're paid based on time, unlike an executor in an estate where you're paid by a percentage of the estate. What are the obligations of the guardian? The guardian has the responsibility of seeing that the bills are paid, determining where the best place to live is for the ward, obtaining necessary medical treatment for the ward, provide financial management for the ward, and they are certainly authorized to seek additional professional support if necessary. In terms of managing mom or dad's finances, you're urged to consult with professionals to make sure there's no breach of your fiduciary duty to fail to act prudently with regard to mom or dad's finances. Now, oftentimes in guardianship disputes where their siblings involved fighting over control over mom and dad, there may be a fight to get mom or dad back to the East Coast or over to California. And so there may be a rush to seek appointment here in Las Vegas or up in Reno to prevent that, to get appointed as guardian and be the lawfully appointed guardian. But there have been situations where, while that was in consideration, one of the siblings will take mom or dad to another state, and they could potentially be in contempt of court. There could be ramifications for that, civil ramifications mostly, for contempt of court. Can the ward be moved to another state? Yes. If you get permission of the home state here in Nevada, you get permission of the guardianship court, you could move mom or dad or even a child to another state. You'd have to have another guardianship in place to accept placement for the ward. Under what circumstances would a guardianship be sought for a minor child? Well, of course, if there's a loss of both parents, or maybe the parents became incapacitated, could not take care of the child anymore. The schools, social service providers were going to want someone who is appointed by the court and subject to the jurisdiction of the court to be appointed before they will deal with them in acting on behalf of the minor. There are occasions where a child has been named a beneficiary of a life insurance policy, and sometimes, in some occasions, very significant life insurance policies. And it's necessary even by the survivor, the father or the mother, whoever the survivor is, to go get appointed guardian to handle $500,000 or $100,000 where the child was named the beneficiary. And mom or dad, the surviving mom or dad, have to understand, and they're told the importance of managing those funds properly. Typically, they're put into a blocked account. Can the surviving spouse get a budget to take care of the minor child? Well, yes, they can. They can submit a budget to the court and say, you know, I've got a lot of responsibilities with my child, and I'm going to need an allowance. And the courts are very accommodating. The guardianship courts are very accommodating in terms of making such an allowance. I failed to mention, I should mention Patricia Doninger down here in Las Vegas, Nevada, handles juvenile guardianships in addition to juvenile custody issues. So she is responsible for some juvenile guardianship cases too. But you can make a petition, ask for allowance for, I've seen instances where allowance is sought for $3,000 a month. For schooling, maybe some supplemental care for the child if they have issues with, they need counseling, where they need counseling. That's certainly allowed. And so the guardian would, in those cases, be seeking maybe Social Security survivor benefits, Social Security disability benefits for the ward, and they would have authority to deal with that and obtain those services for the ward. Now, let's go back here. So we're talking about the different types of guardianship. It's important to have a document where you name that person you'd want to be guardian, even if that person may reside out of state and you understand they're going to have to partner up with a guardian in Nevada. And when you're considering that, it can be on a separate document by itself. We oftentimes put it in our will document or in a healthcare power of attorney document. But a very important aspect of that is you can eliminate the need for a bond. You can name your spouse to be your guardian and say they do not have to go get a bond. If that bond requirement's not waived, you may have to consider a bond, or you may have to leave funds in a blocked account and get permission to, from the court to use those funds that are in a blocked account. A guardian may need to file a lawsuit on behalf of the ward. I've handled several of those where the ward has been exploited. So we get a guardian appointed, we get permission of the court to file a lawsuit against the person who has taken mom or dad's money or property. Now in guardianship court, you can go in and get a citation issued to that person who you believe has property of the ward and drag them into court under penalty of contempt for their failure to show. But a lot of times these people aren't going to show up. You're going to have to file suit or maybe try to seek criminal prosecution. Finally, there's a duty to report to the court. For smaller estates, you do not have to do an annual accounting. That's called a summary guardianship. If your assets are under $100,000, you don't have to do an annual accounting. For estates of a ward that are over 100, you have to provide an annual accounting, and that's a good opportunity to get any attorney fees paid and get the guardian reimbursed for their expenses and paid for their time. I've had situations where there was not much money in the guardianship estate, but there was a trust outside of the guardianship, and we got permission where there were trust funds. Mom or dad had a trust where there were assets, and with the approval of the guardianship court for the validity of those expenditures and of the time, we've gotten permission for payment by the trustee. Now, at this time, I'd like to talk about probate. The probate setup in Nevada consists of a specialized probate court that deals with probate claims, admissions of will to probate, appointment of executors and appointment of administrators. In Clark County, we have a specialized probate court with Leslie Yamashita as the probate commissioner. We have a public administrator, that's John Cahill. His office is a elected office, and Mr. Cahill is responsible for handling estates where there's no other person that may be authorized or could be found to take care of a decedent's estate. I'll give you, for instance, someone is, again, Nevada is unusual, unique. Las Vegas particularly unusual, unique in that people live here without family relatives close by. So they may pass and there's no one within the city or within the state to come to their assistance. They may not even have any living children. And the public administrator may get the first call from the coroner's office to come over and secure the residence and look for any documents and try to find family relatives. In those cases where they're not available, or in cases where there may be family members available and they've petitioned the court for appointment as executor or administrator, but there are such disputes between the parties vying for that appointment that they decide to appoint the public administrator because they can be neutral about it. But the public administrator may be called upon to administer those estates. Now, in probate, you'll hear two terms. You'll hear the term executor as a fiduciary or administrator as a fiduciary. Why do we have two different terms? An executor is a term that's used when there's a will, a last will and testament, that actually names that person who would be appointed as the executor of the estate. An administrator is a person who's appointed when there is no last will and testament, and so that person can seek appointment, and it's by preference. There's a statutory preference. Of course, a spouse would have a primary, be the primary person that would be selected under our statute, and then an adult child after that. So administrator would be someone to be appointed when there was no will, and we're talking about an intestate estate. What is an intestate estate? It means that there was no will indicating who would get property of the decedent, and the property doesn't, people sometimes think is automatically going to go to the state of Nevada. That's not correct. There's a statutory scheme, if you want, setting out who will take if there's no will. I'll give you the most common example. There's a spouse and there's two adult children. In that case, you would have, as to the decedent's separate property and 1/2 of their community property, it would go 1/3 to the spouse and 2/3 to be divided between the two kids. So that's a typical situation we'll see when there's an intestate estate. Probate only deals with assets that aren't already in a trust, assets that need their title changed. Non-probate assets, assets which are not subject to probate, could include life insurance, which has a beneficiary designation, although in some instances we see life insurance policies where there is no beneficiary designated or the beneficiary predeceased the decedent, so it will go to their estate. Many bank accounts have a pay on death designation or transfer on death designation and therefore would not go through probate. Joint accounts or jointly held property would not go through probate. They would go to the surviving joint tenant without the necessity of going to court. We also have a provision in our statutes where someone can execute a deed to real estate, indicating that upon their death, and only upon their death, that real estate will go to the person named in the deed. And that deed can be canceled during this person's lifetime. But that statute is NRS 111.109, and they give you the language that's required to execute that type of deed. But the simplest thing, and the thing I find most useful for dealing with real estate and any other asset, is a revocable trust, and we'll have the other speakers talk about that instrument, and that will help you avoid probate. Why is probate necessary? Protect the assets of the decedent for the heirs, because an administrator or an executor, if there's a will admitted to probate, can deal with creditors. First thing you do is you send out a notice to creditors. If there are known creditors, you send them, you mail them specific notice, but you publish a notice. And that's very important because you can get rid of any unwanted contingent claims that might spring up later. You can deal with them by publishing a notice to creditors and specific creditors sending them a notice. What do you do if a creditor's claim is actually filed? You can take a look at it and decide whether or not to accept it and agree to pay it or to reject it. If you send out a notice of rejection, that creditor has 60 days to file a lawsuit. If they don't, they're forever barred from seeking payment by the estate. So one of the most important aspects of a probate is dealing with creditors and dealing with them once and for all, not have to worry about them years down the road. People will ask, well, why do I need a probate if we have a trust? Well, a trust is only effective as to the assets in the trust. So if assets have been transferred to the trust and the trust is funded, we don't worry about those in a probate. But oftentimes there'll be assets outside of the trust that need to be transferred into the trust to only be distributed according to the terms of the trust. I'll give you a very happy, for instance, had an occasion once where clients of mine had a trust, but they later hit a lottery. One of them had died. They hit the lottery. We had to do a probate to transfer those lottery winnings into the trust to be distributed later according to terms of the trust. An executor administrator has the authority to cite people in who hold property of the decedent and force them to come into the court to turn over the property. The executor administrator can file a lawsuit against those who owe the decedent money. How are we on time? Okay. I'm often asked, how do I locate a will? We do have a will file with the Clark County courts where wills are filed, and there's an obligation to turn over the decedent's will and file it within 30 days of their death. Those are online if people want to try to check and see if a will has been filed with Clark County. One final note, you don't always have to accept an inheritance in probate. Sometimes people will disclaim them if they're receiving other benefits and it might affect their eligibility. You can file a disclaimer in probate and prevent those assets from going to that person and thus jeopardizing their benefits. I want to quickly cover levels of probate administration. If you have an asset or assets under $20,000, you can have those transferred by an affidavit of entitlement. Sometimes people do that with bank accounts. Sometimes they'll do it with a vehicle. Department of Motor Vehicles has their own form they like signed when you're doing those type of transfers. We also have set-asides for estates under $100,000. You can get those done in 2 weeks. You can set aside real estate by pointing out the house is worth 100, but there's a mortgage of 50, therefore the value is only 50,000. If you provide that information to the court, you can set aside that real estate to whomever is named in the will. If they're not named in the will, set aside those persons who would take under intestate succession laws, usually typically family members. There's summary administrations for estates between $100,000 and $200,000. They're a little bit simpler than the general administration, which is for estates over $200,000. So a summary administration will dispense with some notices, and so sometimes that's more appropriate because it's a little bit quicker to get through. I generally go with general administrations because it's only another 30 days for the creditor notice period, and if you inadvertently find another asset that takes it over $200,000, you don't have to extend your probate proceeding or unnecessarily delay the termination of the estate. All right. With that being said, I'll turn the mic over to Marjorie Hauf.
Thank you, Mr. Richardson. Let me just catch up to our where we are. I'm going to talk to you a little bit about more of the wills and trusts aspect of estate planning. Probate is essentially what happens after somebody passes away and you're at that point dealing with the administration of the estate. Let's first figure out what an estate is. An estate is everything you own. Your home, your property, your bank accounts, your investments, your retirement benefits, your IRAs, 401ks, your insurance policies, your collectible property, personal belongings. So everything you own is considered to be part of your estate. Who needs to protect that estate? Who is estate planning right for in the realm of doing a will or a trust? Certainly, as you get older, you're going to want to start considering how you want to transfer your assets to your remaining family members and your loved ones. But the reality is, any person or family with any assets also need to implement an estate planning process in order to protect their children should something happen to them when they're small, or protect your spouse. And we're going to go through some of the reasons why that's important. Even single people need to consider estate planning, although their estate plans can sometimes be simpler than married people, people with a large estate, lots of assets, small children, or even as they get older when the estate distribution is going to be more eminent. It's not just for wealthy people, it's for everybody that has assets that need to be protected or transferred upon your death to somebody else. The goals of your estate plan, when you sit down to prepare one and decide what you want to do, is essentially to provide for your intended beneficiaries. That is, who is the people you want to get your stuff, and why do you want them to have your stuff, and what do you want them to do with your stuff. To avoid probate, which Mr. Richardson has talked about, items that are in property that is in a trust at the time you pass away will not have to go through the probate procedure, and will not have to get approved by the court. It will automatically transfer upon your death. Another important aspect is minimizing your estate tax. And we're going to talk about that a little bit more in a minute, but that's one of the huge benefits of estate planning, is transferring your assets without having to pay estate taxes on them. And additionally, to safeguard yourself if you become incapacitated during your lifetime. Telling the people who are going to be taking care of you what you want them to do. And you can lay that all out in a document so that the guardianships that Mr. Richardson has explained to you are a lot cleaner and more secure and more in tune with your wishes, than they might otherwise be if people are just trying to think about knowing what you might want. All right, the state of the estate tax. This is the most confusing thing about estate planning is dealing with the taxes when you're done. Estate taxes have gone through a sort of bell curve since 2009, when the Economic Growth and Tax Relief Reconciliation Act came in, EGTARA it's called, the acronym. In 2009, the estate tax, if you'd have to have more than $3.5 million of net stuff to get taxed. That was only about 9,000 of the tax returns in the United States that were filed. Then that dropped in 2010. Died in 2010, there was no estate tax. Then the bell curve starts to go back up. Now we're back up to a $5 million exemption, which is only about 4,000 of the returns filed in the United States. You have to have 5.12 million, or $5,120,000 in your net estate. That is after your property is transferred upon your death and deductions are taken. Certain deductions that are allowed to be taken are taken. You'd have to have 5.12 million left in order to be subject to the federal estate tax. Nevada has no state estate tax, just like it has no other common state taxes, income tax, or things like that. So next year, the exemption is going to drop back down in that bell curve to 1 million unless Congress acts unless Congress acts on the Economic Growth and Tax Relief Reconciliation Act. Sort of the buzz in the community seems to be that they will act, they will do something, and depending on who comes into office, it will either probably remain in that $3 million range or raised to an enormous level of probably of the $5 to $10 million range. It's all speculation at this point. Who knows what they're going to do? What I can tell you is probably nothing's going to happen until after the election and after January, and whoever gets their hands in that pot, so to speak. So I guess we'll all wait and see. But unless they do something, it goes back down to 1 million next year. And 1 million is it's a healthy estate, but it's not an insurmountable estate when you think about all the things that we talked about that belong to your estate: your house, your car, any collectibles that you have, your bank accounts, your, relatively anything that you have within your possession goes into that figure. And it's not necessarily what you paid for it, but the value at the time that you pass away. So when should you do this? When should you be thinking about planning for your estate? Now. You should always do this sooner rather than later. You never know what's going to happen. Anything could happen to any of us when we walk out into that parking lot later today. So the sooner rather than later do you want to think about it. You want to do it while you can do it. You want to do it before you need it. As Mr. Richardson was explaining, your estate plan is also going to contain your guardianship provisions, and that's going to be something that's very important to you, laying out what your wishes are. So when you're standing in front of that probate court, it's more, or that guardianship court, I'm sorry, when you're standing in front of the guardianship court, you have more information to make that decision. That judge has more information to make that decision because they have not only you standing there telling them what you want or don't want, but they have the documents that included your wishes when you were still considered to be, when it was uncontested that you were of sound mind. No one wants to think about this, but everybody has to think about it. And you're going to feel better knowing that it's taken care of once it's done. So what do you need to do? There are basically these 5 options, well, 6 options really. We'll talk about the next one in a minute for estate plan. There's a simple will, which will be probated. That's just a document that spells out exactly where you would want your property to go. It also would contain often guardianship provisions for your children, and other transfer of assets without beneficiaries. That will go to the probate court, and somebody will decide, and the court will decide will interpret that document and hopefully do what you want done with it. There's also, obviously, you could do nothing. If you do nothing, what happens is your property will be distributed by what's called intestate succession. And that is a statutory provision that says who gets your belongings if you pass away in the event that you have nothing telling the state what to do with it or nothing telling the probate court what to do with it. And it's set out in a manner, percentages, and who gets what. Ultimately, if there's nobody to take your things, then it goes to the state. The third plan is putting all of your items in joint ownership. And we'll talk about it, and that's a good idea for a lot of families and a lot of situations, but you certainly want to think about the possible ramifications in this climate, in our current civilization where we deal with a lot of blended families and things like that. Joint ownership isn't always the best way to go, because if you have a blended family, and I'll give you an example in a minute of that, if you have a blended family and one spouse passes away who may not be the parent of the children the other spouse wants to achieve things, you can essentially get those other children disinherited if you don't have an estate plan in place. The fourth option is making gifts during your lifetime. We've all probably seen this happen with more elderly relatives who no longer need their things or want who they want to get their things, and they'll gift those during their life. The fifth plan is beneficiary transfers. That's something you're going to put on, like Mr. Richardson had talked about, your pay on death provisions on your bank account or your beneficiary on your life insurance policy. If you put a person, then that thing, the life insurance policy, the bank account, whatever it is, the 401k plan, will automatically transfer to the person you've named as a beneficiary. However, if you name your estate as the beneficiary, you're now back in probate, because the court has to determine who your estate is. The most common and probably the most effective is a complete estate package, which is going to include all of those things we talked about. It's going to include your will, your living will, your trust documents, your guardianship documents. It's going to include all of those things that you would need. We've already talked a little bit about this, so I'm just going to kind of blow through it. A simple will talks about who handles your affairs, who receives your assets, who controls your assets if you die. The only thing that's not going to go into there is things with beneficiary designations like your IRAs, your retirement benefits, your life insurance. But it does not give you control over your assets after you die necessarily. They're going to go through probate. If you do nothing, everything will be distributed intestate like we talked about. You're going to have absolutely no control over your affairs. Joint ownership, this is probably the most common thing. I mean, for example, most of your houses are probably in joint tenancy with a right of survivorship. When that happens, your joint owner, if me and my husband's home is in joint tenancy and I pass away today, he owns the house, period. No probate, no transfer, no other issue involved in that at all. But you have to make sure that if you do that, it's an excellent way to transfer the assets, avoid the taxes, avoid probate, avoid all those ugly words that you're concerned about, but you have to make sure that it is what you want. And like I was talking about, it's something you need to definitely consider in this kind of climate where we currently live. For example, imagine we've got our fictitious couple here, Tom and Sue. Tom dies, Sue gets Tom's inheritance, so Sue now owns everything that was transferred in joint tenancy. Sue dies, only her heirs get. Tom's heirs are now excluded. Now, if Tom's and Sue's heirs are the same people, their children, whatever, if it's the same people, which would usually only be their children, then who cares? But that's not really the way that the world is working these days. So it's really something to be concerned about. And it doesn't avoid probate, that joint ownership, it just postpones it. We didn't have to probate when Tom died, but we do still have to probate when Sue dies. But what if Sue doesn't die right away? What if she goes and gets remarried? Tom dies, Sue gets remarried to John. Sue dies, everything now goes to John. And then when John dies, there's absolutely no obligation to give anything to Sue's heirs or Tom's heirs. So now all their stuff belongs to a family certainly Tom never thought about or intended, and probably Sue never considered that her own heirs would not be taking under that. So they've essentially disinherited Tom and Sue's children. Now, a will, even a simple will, is going to control that asset to some degree, but it's only going to transfer to the joint owner. So it has to be clear about where you want your assets to go and who's going to be the ownership of that, in ownership of them, if you simply do a simple will. So we've talked about there's some risks of joint tenancy, inadvertently disinheriting the beneficiaries. Certainly those children, if they're adults, are going to come back and sue for their parents' belongings that should rightfully belong to them, and you're going to end up in a protracted litigation over that. You completely lose control over the property. And you can end up with the same benefits of this by doing a revocable trust, which we'll talk about a little bit more in a minute, by doing a revocable trust without the same kinds of risks. Gifting, we already talked about. Gifting, you often think it's going to make your life easier, but the reality is you lose control of your assets when you do that. What if you want your car back? You gift it to your child with the intent that you're going to continue to be able to use it until you pass away. Well, if they decide not to give it back to you, there's not a whole lot you can do about it at that point. And there's one other interesting aspect with regards to gifting that most people don't consider with regards to taxation of the estate. It's called the stepped up basis. So essentially what happens is you give a gift, say you give your house to your child. You bought your house back in 1934 for $20,000, and today it's worth $250,000. You give it to the child, the value of that house remains at the $20,000 original purchase price through a gift. So at the time that the child decides to sell the house, they have a $230 tax obligation, tax basis, with regards to a capital gain. Now, that doesn't happen if you inherit through a trust. You have what's called a stepped-up basis. So the value of the asset is considered to be the value of the asset at transfer, not at purchase. And we talked about that a little bit before. It's a good thing and a bad thing. Your estate is taxed based upon the value of the estate at the time of your death, but the transfer is also valued. A transfer through a trust is also valued at the value of the asset at the time of the death. So in this situation, if you had transferred the asset through a trust, the child then goes and sells the house. It's the value at the time of the transfer, and there will be very little, if any, capital gain tax on the transfer. Beneficiary transfers, as we talked about, simply are the line you fill out on all of your documents that have a beneficiary, your life insurance policy, your 401k documents, whatever it might be. However, there are some risks to that as well. If you don't keep it updated, if the beneficiary dies before you do, if you die simultaneously, if that person's not available to take that asset or decides not to take that asset, then it's going to end up in probate with the rest of your estate. And of course, even if you transfer assets to a minor child, the court's still going to get involved because they're going to want to be protecting that. So essentially, a complete estate plan would include all of these areas: the revocable living trust, certificate of trust, the pour-over will. See, now you may be asking yourself, well, what about the stuff that I forget to put in the trust? I mean, obviously, you can't be expected, I'm not going to put these shoes into my trust. That would just be silly. So what's the solution to that? The solution is what's called a pour-over will. And that's simply a document that says, hey, anything I forgot, put it in the trust. And although that document will go through probate, the end result is one that you can still control relatively well. Your powers of attorney, which would deal with your guardianship provisions, what I always call your pull the plug provisions, what you want to happen if somebody's got to decide to pull the plug, what you want them to do. It'll talk about your anatomical gifts if you choose to be a donor, choose to donate your organs to a certain institute, a certain research, or even a certain person. And also a springing power of attorney. And the term springing power of attorney means that it's not in effect the day that you sign it, it's in effect when something happens to you. So that way it still protects your own control over your assets, but it springs or becomes effective at the time that you became incapacitated. All right, so with that, I'll turn it over to Kristin to talk about the revocable, more specifics on the revocable trust.
Great, thank you. Okay, so Ms. Hauf gave us a great lead into estate planning and some of the different options you have, and now we're going to take a look at what I think is the best part about estate planning, a comprehensive estate plan with all of these great documents. So we're talking about a revocable trust, and you may have heard that referred to by a few other names. Some people call it a family trust, some people call it a living trust, some people call it a revocable family living trust. It all means the same thing. Revocable means changeable, so keep that in mind as we go through this. There are a lot of benefits to a revocable trust. Some of these include, the ability to control your assets before and after death, the ability to change it as things change during your life, avoiding probate, and delaying or reducing estate taxes. Okay, so let's lay the groundwork for the revocable trust. This is really the core foundation of a good estate plan in the fact that it really does what most people think a will does. The trust says what happens to your stuff after you die. The key players in the creation of a revocable trust include the grantor. This is the person that creates the trust, sets forth the terms of the trust, funds it with their assets. And then there's also a trustee. This is the person that manages the trust. And then they also have the beneficiaries. Now, in the context of a revocable trust, these are all the same people usually. So for example, my husband and I created a trust where the grantors, we determined what the terms would be, we put our property into it. We are the trustees during our life, meaning that we manage the trust and its assets. We're the primary beneficiaries for our lives. And then we've determined who will be the successor trustees and successor beneficiaries upon our death. Okay, so that's kind of the foundation of how you create this trust. One of the key things to keep in mind in all of this is control. Control over the assets during life and upon death. You get to determine how and when and who gets your stuff. That's the key concept here. We've talked a little bit about this, so I'm just going to go on. Okay, will a trust help you avoid probate? The answer is yes, so long as you have properly funded the trust with your assets. This is kind of an abstract concept, so think of it this way. When I die, anything that I own in my name, Kristin Tyler, will have to go through the probate court because I'm gone, I'm dead. I can't determine what happens to my asset anymore, so that is then left to the court. However, if I've set up a trust and I put my asset in the trust is still in existence and continues to exist even after I'm long gone, okay? And that's the concept here, is the trust is perpetual and goes on even when you're gone, hence it helps you avoid probate. Okay, so how do you get your assets into the trust? You're maybe wondering this. This involves a couple of different things. For real estate, it involves a deed, not that complicated. You deed the property into the trust. For other assets, like say a bank account, you use the document called the certificate of trust. You take it in, you show the bank or the other financial institution the certificate of trust, which just has the key terms they need to know: who's the grantor, who's the trustee. They don't need to know the rest of your private business. and then they will transfer the account title from your name to the name of your trust. And then there's other ways to transfer other assets like business interests. You can assign your personal property in, and there's a way to transfer pretty much any kind of asset. In all of this, it's important to remember that you remain in control of your assets. It's maybe a little scary to think of, well, I'm going to take my bank account and take my name off of it and put it into a trust. That maybe is a little confusing or scary. But the thing to keep in mind is that with a revocable trust, you still manage and operate and control the assets the same way as you would if you own them in your name outright. The advantage here is being able to set forth the terms of the trust, which tell you what happens to the stuff upon your death or incapacity, and knowing that you will be able to avoid probate. So in fact, you really have more control using the trust structure. Okay, so this chart does a good job of showing the benefits of a will versus a trust. The key things to keep in mind are that with a trust, you avoid probate. You will have fewer court costs and legal fees generally if you have a trust than if you only have a will. The time frame to go through probate with a will is much longer than the trust administration. Trust administration is generally faster, more efficient. You have a lot more flexibility and control over your assets and your estate using a trust. And lastly, privacy. With a will that gets filed with the court, everything's out there in the open for anyone to know. With a trust, there's no requirement to record it with the county recorder. You're able to keep your business private, which is very appealing for a lot of clients. So you always get the question, okay, well, I need a trust, I get that, but do I still need a will? Yes, you still need a will because the will does a couple of key things. You name your executor. That's the person that will, probably their most important job is to file your last tax return. You will also nominate a guardian for any minor children in your will. You'll nominate a guardian for yourself in the event of incapacity during life, as we talked about earlier. And then lastly is this pour-over clause, which is basically the catch-all that goes in and says, okay, if I forgot to put any assets in my trust during my life, I want you to go ahead and pour those into my trust upon my death, so they'll be combined with all my other assets and be distributed according to the terms of my trust. Now keep in mind, any assets that go into the trust via the pour-over clause still have to be probated, but at least you know they will ultimately end up in the trust and be distributed according to those terms. Okay, so now let's briefly talk about the powers of attorney. Nevada has statutory powers of attorney for both healthcare and finances. That means that our lawmakers have gone in and created a statutory form that they want everybody to use. So the idea is consistency, so healthcare providers see this form, they know it's governed by state law, and they'll accept it and honor its terms. The big idea here is that you are naming someone as your healthcare agent to act on your behalf and make healthcare decisions for you if you're not able to do that for whatever reason. You're either so sick, or you're in a coma, or you've been deemed mentally incapacitated and you can't make your own healthcare decisions. This person's gonna step into your role to decide who's the best doctor for you, what's the best course of treatment, are you gonna stay at home or go into a nursing facility, all those types of things. Now, a lot of people always say, okay, where do I check the box to pull the plug? There's no magic check the box on our form to pull the plug. You're able to indicate your wishes about certain scenarios, such as if you were in a coma that they don't believe you're going to come out of. Would you want to continue on artificial life support or not? You can make indications about certain situations, but there's no magic check the box to pull the plug here. So it's important that you nominate someone to be your healthcare agent that knows your wishes, would know what you would want in certain circumstances, and that you trust to make the best decisions on your behalf. The financial power of attorney is the same concept. Again, it's a statutory document. The reason for that is we want consistency in the document. So banks and other financial institutions know it, they will honor it, no questions asked. And again, here you're gonna name someone that will transact business and take care of your finances in your place if you're unable to. Maybe you're off on a great island vacation to Fiji, or maybe you're so sick and you just can't go to the bank. Either way, this person can then act on your behalf. Okay, we mentioned this briefly earlier, but there are some assets that we don't put into the trust. These are what we call the non-probate probate assets. The reason for that is they are strictly governed by the beneficiary designation on the form for the asset. So IRAs, 401ks, annuities, life insurance, things like that. You want to make sure the beneficiary designations on those are the way you want them, because that's what's going to govern that asset. It's not going to be your will, it's not going to be your trust. It's the beneficiary designation. So maybe you're sitting here and you're thinking, you know, okay, I've already got this covered. I've got a will, I've got a trust, but there are some times when you need to think about updating them. And those are really whenever a big life event occurs, a birth, a death, a marriage, a divorce. Maybe 20 years has gone by and you haven't updated your will since then, and your kids are grown now, and maybe you want your son to be your executor now and not your brother, you know? So any passage of time, you want to take another look at that. A move to a new state, it's a good time to check in with an attorney to find out if there's any particular laws in that state. Maybe they do have a state estate tax that you need to take into consideration. And of course, if you win the lottery and hit it big, that's another good time to take another look at that estate plan to see if you need to do some more tax planning, okay? So lastly, we're gonna touch just briefly on the issue of Medicaid planning. Now, when you talk about Medicaid planning, the thing to keep in mind here is that we're not in any way talking about cheating or gaming the system, okay? We're talking about looking at what the laws are and planning in accordance with the laws to protect what we can and to plan. The biggest thing with Medicaid planning is to do it as far in advance as you can. If you know, based on your parents' medical issues or your own health, that there's a really good chance you might end up in a nursing home someday, you really should consider long-term care insurance. And kind of the sweet spot where long-term care insurance gets really expensive is around 55 years of age. After that, the premiums get really high. So it's, think about it sooner rather than later. And if you think that there's a chance you're gonna need this kind of care, it's worthwhile to look into long-term care insurance. We're gonna talk more about the 5-year look back in a minute. The biggest thing with Medicaid planning is understanding what assets are exempt and what assets count towards your qualification for Medicaid. So under state law, and this varies in every state, which is why Medicaid is kind of a tricky area to plan for, there are certain assets which are exempt. In Nevada, it's things like your homestead, your primary residence up to $550,000 worth of equity. So for most of us in this economic climate, it's your whole house. One vehicle, retirement accounts up to $500,000. There was a recent change in law last year so that if you have whole life insurance that has like a cash value build up in it, an investment aspect, that's entirely exempt. Same thing for annuities. So it's a good idea to look at your assets that are exempt and then what assets aren't. So maybe you have rental properties outside of your primary residence. Those aren't exempt. Those are potentially countable assets towards your qualification. And also, I just want to make sure and make it 100% clear that using a revocable trust does not magically protect those assets from counting towards Medicaid eligibility. A revocable trust does not give you asset protection. It gives you control over your assets and probate avoidance. So, there's only really a few ways to pay for long-term care. You're either going to pay for it out of your own pocket, you're going to have planned in advance and got long-term care insurance, maybe you qualify for some veterans benefits, or you're going to get Medicaid. Medicare, totally separate program, does not pay for long-term care. It only pays for short-term rehabilitative care. So if you are on Medicare and later get moved to a long-term nursing facility, then you're going to be looking at applying for Medicaid if you can't pay for it on your own or you don't have insurance. Okay, so how do you qualify for Medicaid? Of course, you have to have a medical need for that particular type of long-term care. They're going to look at your assets, your resources, and determine what assets count towards it that have to be used before you can go on Medicaid. They'll look at your income, and the general rule is as long as you make less income than the cost of private care costs, you'll qualify. Most facilities here in Las Vegas run anywhere from $5,000, $6,000, $7,000 a month. So it can get very expensive very fast. And then last, here comes that 5-year rule. They're going to look at any transfers you've made of assets in the last 5 years. So maybe a parent was starting to get concerned that they might have to go to a nursing home and they deeded their house to son. And then 3 years later, they're applying for Medicaid. Well, guess what? That house, the value of that house is still going to count, even though son now owns it, because you transferred it within 5 years. Again, if you're looking to make transfers to try to plan in this way, you got to look out long term and get ahead of that 5-year rule. So again, it's all about knowing the rules, following them, and if you're going to try to cheat or game the system, you're going to lose. So that wraps it up for our presentation, and I believe we'll now open it up to questions. Would you guys like to join me?
I know we've gone past our 8 o'clock time. Is everyone up for some questions? All right. Well, in the case of a guardianship, who pays for a court-ordered evaluation? I guess this is regarding capacity.
Yes. If the court requests that it be done, many times the court will absorb it. It'll be done for the benefit of the court. But oftentimes a family member will pay for it. They'll offer to pay for it to have it done if there's a question. But sometimes the attorneys will try to get it into court, have the question thrown up to the guardianship commissioner, where he will order it and use psychiatrists that the court's familiar with. In that case, it may not be charged to either of the parties. But sometimes a party will absorb it because they want to establish that mom or dad truly needs this, and it's over the objection of some other sibling. So it will depend, I guess. The answer is it will depend.
Okay. If I sit down and write my will on a piece of paper, is that valid?
Yes, it is. Yeah, holographic will is valid in Nevada. However, you need to know what you're doing. If I can give a quick real-life example, there was a recent case that was in the newspaper, maybe you saw it, where a gentleman had a holographic handwritten will that said, I want to leave my estate to my girlfriend and don't give a single penny to my family. That's essentially what it said. So what happened? The girlfriend died before him. So we have a will that says don't give a single penny to my family. So the family, it was about a $3 million estate, so a lot of money. The family came in and fought for it, and the state came in and fought for it, because the state said, you know what, he cut out his whole family, and if that's the case, then it escheats to the state, and according to our laws, it's used for education. And I guess the good news for our education system is that the state won, and the $3 million went to our education fund. So that's a good example where if you would have met with an estate planning attorney, they would have said, okay, well, what happens if their girlfriend dies? Then what? Let's plan for some more contingencies here.
Is there any special process to pass your assets to a relative living out of the country?
No, you name them, and whenever I have clients leaving assets to someone out of the country, I always get very detailed contact information, so we don't have to hire an investigator to go travel abroad and find them. There's no special taxes here. I mean, we would deal with your normal estate taxes, and then it passes to them, and then if it's subject to taxes in that state, that country, they would deal with those there.
Okay. Is there a statute of limitations in which one has to contest a will?
Yes, there is.
What is it?
Well, if a will is admitted to probate, you have a certain period of time to contest it. I think I have to look at it, I always have to check. I think it's 90 days to file your contest. Otherwise, it will be admitted and forever hold your peace. There can be challenges to trust. The longest date to look at is maybe 3 years from knowledge of the terms of the trust. That's if you're not given a statutory notice regarding a trust. Oftentimes, a trust attorney will send out a notice when someone dies saying, here's the trust, it was changed or maybe not changed, or you're a beneficiary named in paragraph 25, but only for a limited amount. You have 120 days to challenge this. So we now have a statutory trigger that you can put in place if you're representing the decedent's trust.
Okay. If the executor or other representative of the estate fails to perform his or her duties, what happens?
Well, they can be removed for failure to perform their duties. If they've breached their fiduciary duty, they could be sued. If there's a bond in place, someone could try to go after the bond for their breach. But first of all, they'll be removed. They'll be asked to account, provide an accounting. So there's a mechanism.
Okay. If the executor or other representative of the estate dies and there's no successor, who who distributes the estate?
Oh, well, there would be someone that would petition for appointment as successor, executor, or administrator to complete the probate process and make sure the assets are distributed. So if there's no provision in the will that indicates who that successor is, you would have maybe a family member, or if there's no one available, maybe even the public administrator or some private fiduciary that's qualified.
A person suspects that a caregiver has exploited an elderly person. Where does the family member turn to get the authorities involved?
Well, you can call Senior Protective Services, have them make a visit to the home. You can petition for appointment of a guardian for that person, and that person, after becoming guardian, can initiate an action to bring the exploiter in, make him turn over property, or maybe initiate a civil suit against the exploiter for recovery of those funds. But first of all, you try to get a guardianship right away. You might start off with calling Senior Protective Services, but ultimately you're going to have to get in and get a guardianship, get a guardian appointed.
Okay. Well, I'd like to thank everyone for attending and thank Mr. Richardson and Ms. Hauf and Ms. Tyler for an excellent presentation on a very involved area of the law.